The amount of legal guesswork, conjecture, misleading information, and pure speculation regarding artificially created artwork is staggering at the moment. The catastrophic mix of artists being the most emotionally driven category of people, meanwhile law workers being one of the most rigid people, amounts to a horrible game of guessing, exceptionally from the artist's side, where almost everything is wrong. My name is H.P. Rutherborg, and I'm a painter, artist, and lawyer from the southern part of Sweden. I specialize in IP and contract law. Now, first, we need to do some housekeeping in what we're talking about. To even start a legal matter, you need to know 3 essential things. It's what, who, when, and sometimes why. Let's start with what. What needs protection from what? This is an academic question that we don't need to make more complicated than it actually is. Because it's actually the creator that is protected by IP law and not the IP itself. Let's just say, for the ease of the matter, that we want to protect an artwork, such as a painting, photography, song, illustration. And we want that protected from what? We want that protected from copyright infringements, such as the right to make copies and get paid for artwork processing that requires the creator's consent. Now, what is IP law? Intellectual property law, or as we say in Sweden, immaterialrätt, that will be translated into unmaterial law, referring to the actual lack of rights connected to a physical thing. The IP right is connected to a person, either a judicial person like a company or a physical person like a person as you and me watching this. To start off, there is not one global IP law. There are multiple laws under different sanctions. For an instance, European IP law is governed by the European Court or Tribunal. But every country practices their IP law in the way that they have decided to use it. For an instance, the United States has something called fair use. We don't have that in the EU. IP law covers a major amount of legal question. First out, we have market law, which refers to the commercial targeting like advertisement of products and services. We have patent law, referring to the rigid registration of a certain technical or biological design with a specific function. We have trademark law, such as registered or ingrained logo types, names, or specific designs connected to companies. We have patent right law, where you can register a unique pattern, design, like a pattern on a blanket or a print on a cup, for a certain amount of time in a certain area. And last but not least, we have copyright law, which is the most relevant to answer the question in this video. Now, what is copyright law and how does it emerge? Copyright, or the right to make copies, emerges when you create something that reaches what we lawyers call the threshold of originality. Now, what is that, and what does that give the creator? For a work that reaches the threshold of originality, it has to be original and reach a certain level of subjective quality. This is not protected by copyright law, but this is. A copyrighted work gives 2 protections. First, the economic rights, and second, the ideal right. The economic right is transactional, which means it's transferable in the sense that I can agree to let you benefit economically by using work I created. The ideal right points to the respect of the creator. This right is not transactionally supported by law, but it can be omitted by the creator. This means if I were to buy an artwork that reaches threshold originality, I can alter it in a disrespectful way without being held responsible for the assessed damages of the creator's reputation. You cannot get a copyright for a style or a process of work like Sargent, Renoir, or Norman Rockwell. They are not copyrighted styles. The sanctions or the punishments within copyright breach is very complicated. It's both criminal and civil. And going into that, I would need a lot more time. But why it is both criminal and civil is to enable the creator's capacity to claim replacement of pure economic damages within a civil lawsuit. Purely economic damages is basically what you would have made if the breach never happened. This is super hard to prove, which is why it's very rare to go into trial claiming this. Other than that, the most common sanction I demand when I litigate within copyright lawsuits is for the defendant to cease with selling my client's copyrighted merchandise. There is, however, a possibility to use already copyrighted work if you change the essence of the copyrighted work. The legal terminology is satire, parody, pastiche, where the work cannot reasonably be confused with the original copyrighted work. There is also, according to case law, various instances where work purely materially is so far removed from the original that it obtains its own threshold of originality. Such identifiable aspects would be painting and photography, where painting is a media so far removed from photography that it becomes a new artwork, simply because it cannot be confused. The time the work is protected by copyright law depends completely where the creator is claiming the copyrighted material. For example, in Sweden, the copyright outlives the creator with like 70 years. Now when we know what copyright is, how it comes to exist, the sanctions, when it dies, now we need to answer the questions is, who are the players? We have the AI, the artificial intelligence. We have the person owning the AI. We have the person that created the artwork the AI is using to create responsive artwork. And then we have the person using the AI to create new artwork in their name. I assume you know what AI is, so I won't go into that. Therefore, is the first question, can AI create something that passes the threshold of originality? And is AI a person with legal status and therefore protected by copyright law? The first question, can AI spontaneously, with algorithms and available data, with minor input from a third part, create artwork passing the threshold of originality? I would venture, for the sake of argument, answer yes to that question without diving too deep into the actual technical aspects of how, for an example, DALL-E functions. The next question, is AI a legal entity in the sense that it can have rights to sue someone? Does AI have the legal status of a company or a person? Many arguments have been put forward, including that AI should be considered a legal person and equated with a limited company. After all, much remains to be done, both in form of technical development and in form of legal analysis and argumentation regarding how AI should be treated legally and whether it should be considered a legal person or not. I come to the conclusion that AI today has no legal personhood or legal capacity. However, AI may sometimes, in some situations, be recognized as an agent and act on the behalf of another legal person. So today, as far as a person that can obtain a copyrighted protection, as a person with a legal status, the answer is no. But it can work as an agent under the umbrella of a company that in their turn has a legal status and therefore is copyright protected. Now we have concluded that AI can create artwork passing the threshold of originality, but it does not have the protective status of a company or a person when it comes to copyright law. We can now stop using AI as a part of the legal issue and replace it with the person with legal status. That is the owner of the AI. For the rest of this video, we will call the owner of the AI Owner 1. Now, where and from who does the Owner 1 get its data for the app to create the work? In this case, artwork like DALL-E. Now, keep in mind the economic and the ideal protection and also the threshold of originality. So the data Owner 1 uses to create artwork with the AI might not be at the standard to in itself obtain copyright protection. Or if it does, the economic right might already have been handed over from the original creator to Owner 1 without our knowledge. So what happened between, or whatever contract Owner 1 has with the data creators, is open or uncertain knowledge. The next part, who is the user of Owner 1's products and what responsibility does that entail? The relationship between Owner 1 and the user for these on-demand created artworks is regulated by contract law. Who owns what and what they can do with what artwork and where is most certainly a contract issue. However, for the sake of argument, if the agreement between the user and Owner 1 states that the user owns the work created in the keyword input dashboard and the third party, the data creators, were to claim that the user unfairly used their artwork without their consent, the user would be responsible for copyright breach according to copyright law, but the user would have a good contract claim of the Owner 1 for whatever damage the copyright protected creator got out of the user. So whenever artists or artfluencers talk about law connecting to art, I cringe, I get hurt, simply for the fact that I know that they don't know. Even if you've been an artist for many years and dabbled in this area of IP law, you don't know because we lawyers, we don't know. This is very complicated contract law connected with copyright law, connected with subjective assessment from case to case. My personal opinion is that it's so rare to have copyright disputes within the art world. My personal opinion is that it's very rare to have copyright disputes within the art world. There may be a handful of artists that actually needs protection, and these artists are often industry designers that creates something that has not been able to get a registration, or the registration time ran out, and they can use their lifetime copyright protection to lock in future economic or ideal rights. Painting, photography, and illustrations is very unlikely to be a part of litigation, since the economic interest is very low and unproportional to what you can obtain in the best case. My assessment is that the art world, and particularly artists, is suffering from a famine mentality and is trying to throw rocks into the AI machinery of an amazing new feature that would change art forever. There is no general legal issue with this new AI function. Will it be? 100%. It's basically all contractual. And because artists are generally afraid of contracts and like to throw around words like copyright without actually knowing the meaning, it confuses people. I hope I shed some light in this area because it's very complicated. And I take issue with non-lawyers discussing the legal matters of this particular subject. And I think artfluencers, artists should stick to talk about techniques like the Loomis method, pencils, different mediums, things that is connected with actually creating the art. Leave the legal matters to lawyers. I'm very interested in the body, the physiology. I would never give health advice to anyone because I'm an idiot and I know nothing about it.